Will XURP be able to return the $1 price? How will the trial end? Can Ripple beat the SEC? We will answer these questions in today's video. David Schwartz, Deaton of the financial juggernaut Ripple, has updated his Twitter profile picture to include an image with a message. The SEC's complaint against Ripple is described by the context and the term Ripple at the top. The crypto community is speculating on what Schwartz means, and if this provides any clues as to the case's probable resolution. The cover blurb reads, "When a scrappy financial company takes on a web of deceit and treachery to provide quick payments to the public, they realize that the cost of changing the status quo is more than they could have expected, forcing them to choose between their vision and their survival." Several crypto aficionados on Twitter have shared images of this message in an attempt to decipher what it means, as the C2 of Ripple and a co-creator of XURP Ledger. They all agree, however, that this has been going on since late December 2020 and is all about a legal battle with the U.S. Securities Authority. Many in the XURP army have taken to Twitter to express their admiration for Schwartz, Ripple CEO Brad Garlinghouse, and the rest of the Ripple executive team, as well as the legal team who are fighting to win the case and, in the eyes of many crypto enthusiasts, save the cryptocurrency industry from strict regulation by the SEC. The SEC appears determined to declare cryptocurrencies to be securities and to regulate them using securities laws from the dated early 20th century. According to the Twitter account Ashley Prosperone, the message Schwartz shared implies that Ripple may have to compromise their vision for the company in order to survive as a company, i.e., just get the SEC to acknowledge XURP as a non-security, a status Bitcoin and Ethereum have from the regulator. Crypto Law. US founder and outspoken Ripple defender John Deaton has revealed what he thinks to be the primary condition on which the fintech business will agree to settle with the SEC. This, he claims in a recent discussion on Twitter, would happen if the SEC signs a document declaring that XURP is not a security. This would apply to both current and future sales of XURP, as well as secondary market sales of XURP by any person or organization, including cryptocurrency exchanges. According to him, 1010 attorneys suggest settlement in this situation. Deaton doesn't think Ripple would hold out for a better deal since it would fight for all of crypto. As Ripple is a fiduciary to its shareholders, he is certain that it would have to reach a settlement. Ripple would be in litigation for a decade if they didn't settle the complaint and then lost in court. Formerly, it was reported that attorney John E. Deaton said the sole success the United States Securities and Exchange Commission will likely claim in its lawsuit against Ripple is that the blockchain payments firm offered XRP as Ether as a securities from 2013 to 2017. The attorney, who is representing over 75,000 XURP investors as a friend of the court in the dispute, provided further detail about his assertions in a long Twitter thread yesterday. The market regulator does not perform a special how-we analysis by identifying transactions that constituted securities offers, as explained by Deaton in the discussion. Instead, he claims the market regulator is making the case that all XRP sales are in fact securities by using what he calls the but for test. The SEC's argument, according to Deaton, is that all XRP represents securities regardless of the circumstances of the transaction, since Ripple helped establish a secondary market for XRP. The SEC's assertion in its summary judgment motion is the basis for the attorney's opinion. The SEC argued that the investment of money prong of the Howey test was met because defendants did not deny that they offered and sold XRP in return for money, meaning fiat currency. To paraphrase the court's opinion, defendants' assertions and actions as to XURP establish the other components of the Howey test as a matter of law. The but for test, as a reminder, is used to establish fault in tort and criminal proceedings by showing that a certain result is the direct consequence of the defendant's actions and would not have occurred under alternative circumstances. In addition, Deaton notes that the SEC avoids doing a full Howey analysis by placing too much emphasis on the XRP coin. The market regulator's contention that XRP is symbolic of both the investment contract and the joint venture is shown by the lawyer. The attorney objects, explaining that this is not how Howey is implemented, as it is the particulars of the transaction that often decide whether or not an offering constitutes an investment contract. Remember that Deaton has stressed that an investment contract's underlying asset cannot, in and of itself, constitute a security. Apparently, the lawyer was able to persuade the court to agree with him in the Lowbury case, resulting in a formal admission of this fact by the SEC. A good how analysis led by the conditions of the sale would limit things down to particular transactions, not all excerpt sales, as it now claims, and the attorney feels that the SEC might have had an easy and winning case if it had done so. Deaton wrote in the thread, "This is why I said the SEC may have snatched defeat from the jaws of victory," after disclosing that he has pointed out to Judge Annalisa Torres that the SEC's claims in the Ripple case are potentially the broadest and farthest-reaching claims the regulator has made in any enforcement action. As the papers in the case have been filed and the parties are now waiting for a verdict, discussions have naturally turned to the various outcomes. Deaton has said that he anticipates a trial by jury. When Brad Garlinghouse joined Ripple Labs in 2015, he certainly didn't expect to be at the center of one of cryptocurrency's greatest legal disputes. Garlinghouse has extensive company experience and fights regulators. Garlinghouse attributes his work ethic and honesty and responsibility to his Midwest heritage. Can Ripple's CEO fight for blockchain's future after working at some of the internet's top companies? Who leads Ripple Labs against the SEC with Chris Larson? We must go back to comprehend Garlinghouse's crypto market ambitions. Charles Hoskinson and Gavin Wood are computer science, trained blockchain leaders. The XRP founder comes from a business and economics background, not New York or San Francisco. Hutchinson, Kansas, reared Brad Garlinghouse. Garlinghouse was raised in a tiny Midwest town and values family and community. Wichita Southeast High School and the University of Kansas gave him a BA in economics in 1994. Garlinghouse completed his MBA at Harvard Business School in 1999 with bigger goals. Garlinghouse interned at Allen Company, an investment banking company, while college. Garlinghouse worked as a JP Morgan analyst for 6 years after graduating from Harvard Business School. These years exposed Garlinghouse to Wall Street and the World Economic Forum. Early internet giant Yahoo hired Brad Garlinghouse. Garlinghouse developed Yahoo Mail as Senior Vice President of Communications and Communications and Community. These platforms are the foundation of the current internet. Garlinghouse is most known for the Peanut Butter Manifesto after his contributions to Yahoo. This famous memo called on Yahoo to simplify processes. Fintech companies shared the message. In 2009, Garlinghouse became president of consumer apps at AOL. He developed AOL Mail and instant messaging in this capacity. Garlinghouse also ran AOL Ventures. Bebo's purchase presented fresh issues. AOL Ventures sold Bebo 2 years later at a fraction of their acquisition price, making this move a failure. Brad Garlinghouse left Silver Lake Partners to work on blockchain and digital assets. Garlinghouse identified Dell MC, Airbnb, and Alibaba Group investment prospects as managing director. Garlinghouse was also a senior exec at Hightail. Garlinghouse made sure Hightail kept offering creative productivity solutions to its global customers after rebranding from Usendit. Garlinghouse left corporate life to join Chris Larson at Ripple Labs in 2015. Since then, Ripple's CEO has led its growth in XRP development. Garlinghouse has advocated using blockchain to address banking regulations and cybersecurity. His outspokenness has made him a target of the SEC's cryptocurrency assault. The SEC's lawsuit against Ripple Labs has tarnished the blockchain company's CEO. The complaint seeks to clarify how the SEC regulates XRP. Brad Garlinghouse and Ripple Labs call XRP a currency, whereas the SEC calls it a securities. Ripple Labs and XRP have suffered from the litigation, with Coinbase removing the coin. Fear, uncertainty, and doubt have clouded XRP's prospects in previous bull markets due to reduced trading liquidity. The lawsuit should be resolved by mid-2023. The SEC's crypto and blockchain crackdowns continue. The SEC penalized Kraken $30 in February 2020, $3 for their staking offering.